From the east to the west to the north to the south.
In our ways, children, wakanja, are sacred, or wakam. Dakota language shines the light on the Dakota value of their children. Wakanja is simply defined as the sacred one. Children are gifts the Creator sends to carry our traditions, our stories, and our hopes. How do we protect our wakanja?
Let's talk about the Indian Child Welfare Act, or ICWA. This federal law was passed in 1978 because Native American children were being removed from their homes at shockingly high rates. This wasn't just about taking kids out of unsafe situations. It was often about removing them from their culture and communities. ICWA was designed to stop that and protect the connections Native kids have to their families, traditions, and tribes. ICWA applies to all 574 federally recognized tribes in the United States. 11 of those tribes are here in Minnesota, 7 Ojibwe, and 4 Dakota. Before ICWA, about 75 to 80% of Native families living on reservations lost at least one child to the foster care system. Why? Child welfare agencies often did not understand or did not care to understand Native cultures and parenting practices. That lack of understanding led to a lot of unnecessary placements in non-Native homes. Native status is not about race, it's a legal and political status. Each tribe has its own criteria for membership, and only the tribe can determine who qualifies. This is where ICWA steps in. It provides critical legal protections for Native children who are eligible for tribal membership. It also makes sure their rights under both tribal and federal law are upheld. That's why in child protection or welfare cases, it's required to ask families about their Native heritage. Asking these questions, what's called inquiry, is the foundation of ICWA and the Minnesota Indian Family Preservation Act, or MIFPA. Without it, we cannot know if a child or family has Native heritage unless they tell us. And it's important to understand that inquiry isn't about assumptions. It's not based on how someone looks, what their name is, or stereotypes. If a child's Native status is confirmed by their tribe, ICWA and MIFPA outline specific steps we have to follow, like sending notices, making active efforts to keep the family together, involving qualified expert witnesses, and prioritizing placement within the tribe. Even if there is a reason to believe a child might be Native, these protections apply until the tribe makes a final determination. ICWA isn't optional. It's a promise to honor and protect the rights of Native children, families, and tribes.
You may be the first person who can ask the important questions. You're the one who must find out, is this child ICWA or MIFPA eligible? It is the first way we protect that child's cultural identity. Imagine a child growing up knowing their traditions, dancing at tribal gatherings, hearing the old stories from their elders. That is what ICWA and MIFPA are for, to make sure our children grow up knowing who they are. ICWA and MIFPA are not just laws, they are promises. Promises to our children that they will stay connected to their people, to their stories, to their language. When you follow these laws, you are doing more than checking a box. You are protecting the heart of a child's identity. You are honoring the bond that keeps our communities alive and preserving the future of our people.